Thanks for having me along. I'd also like to acknowledge the traditional owners of the land upon which we meet and pay my respects to elders past, present and emerging. And I'd also like to thank and acknowledge all of the stakeholders, the tenants, the landlords, the lawyers, the advocates, all those who've registered for the session and given up an hour of their time to listen to my dulcet tones. I really appreciate you joining us this evening. And I'm hoping that tonight's presentation will give you some things that you might not have known about, some information that you can go away and think about, and also more information about what our office does for the Queensland Small Business Commissioner. And I'm going to start sharing my PowerPoint slide now, so bear with me while I do that. That should be good now. As mentioned, I run the assistance team for the Queensland Small Business Commissioner, Dominic Lamb, and my team is a small team, and effectively our role is to reduce the time and cost involved in resolving disputes for small businesses. But we don't only just do that for small businesses, we do it for those that they're in dispute with, whether it be landlords, other businesses, government. We actually play a very neutral, I should say, role in dispute resolution. So we also provide a central point of contact for small businesses. We do one-on-one information, guidance. We help them find the right doors to get information, and we point them to things that will actually really help them. One of the unique things about our office is that you'll speak to a human when you talk to us. So you absolutely will talk to one of my team, usually Kate, when you ring our number in the first instance. And then I have business liaison officers who work with me to make sure that we provide information to both small businesses and landlords and other parties like stakeholders as well. There's a second part to the team in the QSBC, which we work really closely with, the advocacy team. Our role there is to feed information and what we see in our disputes across to the advocacy team so that they can take that, inform government about what the challenges are, and in order to inform policy. They also run the Small Business Friendly program. Small Business Friendly program is run in every state of Australia. We run it here and we have, I think it's 45. We've just signed 2 new ones, so forgive me if I got that wrong, 45 councils, but I know that those councils do cover 80% of the 473,000 small businesses in Queensland. And I'm not sure if you knew, but 97% of all businesses in Queensland are small. And so it's the advocacy team's role to try to enhance the operating environment for small businesses in Queensland, and we feed them the information that helps them do that. Sorry for the echo there if that came through. Go to the next slide. Tonight's topic is around commercial tenant agreements, and there was just a couple of things I wanted to cover off before we got started. One of them is that I am not a lawyer. I am not legally trained or anything like that. Sorry. All right, so yeah, there were a couple of things that I wanted to cover. One was that we're joined by a number of solicitors, lawyers, tenants advocates, landlords, tenants. Some of these have amazing expertise in the area of commercial leases, and I'll be talking about that more later. But one of the things I wanted to point out was that I'm not legally trained, I'm not a lawyer. None of my information tonight is designed to be or intended to be legal advice. And I'm also going to use a few acronyms and a couple of other terms that I just wanted to define at the beginning. One being commercial leases. So I use that term to cover both retail shop leases, which are covered under the Retail Shop Leases Act in Queensland, and also non-retail premises or any other business premises, and obviously commercial, it isn't referring to residential. There's a really important reason for me pointing that out, because in Queensland, residential tenancies are covered by standard terms in their leases, which can't be altered. And I know that because I took that quote, that exact wording, directly from the Residential Tenancies Authority website. I know that for sure. And something else I know for sure from experience is that tenancy agreements in the commercial land can come in all shapes and sizes, and there is really no standard lease or no prescribed lease to use in the commercial world. It's also important to note that a retail shop lease, this was something I didn't know when I started with the Commissioner's Office 3 years ago. A retail shop lease doesn't have at the top of it, this is a retail shop lease. The things that make it a retail shop lease are where the premises are located and what the premises does. So is the business on the premises a retail shop, and then is it in a shopping centre or a shopping strip and things like that. So it won't necessarily say at the top, like a residential tenancy agreement says at the top, it won't say this is a retail shop lease. But there's also a lot of other law and codes, things like that, that dictate things that we might be talking about tonight. I mentioned a few of them there. And case law and precedent is really important. So I just wanted to point those out before we went any further. And so the point I was making before is that I'm no expert in the commercial leasing market that's out there. There are plenty of people with a huge amount of expertise, some of them online tonight watching. These are companies who represent lessees and lessors for a fee, which we don't do. For tenants, there are specialist firms providing advocacy services. They offer wide-ranging tenant consultancy services encompassing things like lease information, research, site sourcing, selection, dispute resolution, retail franchising, portfolio administration, and lessors likewise, or landlords likewise, have information and advisory services available through commercial property agents and landlords agents as well, and landlord consultants. So I've done a really, really quick snapshot of the commercial leasing market from some of the information that's available either through the Property Council of Australia or some of those tenancy advocates. And I've put some of the information there. And it's really just to set the scene about what's the situation in the commercial leasing world at the moment. So when we talk commercial leasing market, there's really three key areas: office, industrial, and retail. In Brisbane, the office market is different from Sydney and Melbourne at the moment. Both Perth and Brisbane are seeing declines in the office space vacancy rates, and that's from the Property Council of Australia data shows that. Brisbane CBD and fringe sectors saw the greatest net increase of office space being leased in the past year. And there is a slow return to work, many of you will know, but research is showing that there are some negative impacts of work from home, and there is a move back for people to move back in the offices. And another term you might hear is a flight to quality. There is a sense that landlords are trying to give the best quality office spaces available in order to entice people back to the office. Very quick snapshot there, industrial. There was just one thing I wanted to note, which was some of the ASX listed companies like Goodman, Mirvac, Stockland. It's reported that they could be striking new leases at logistics assets as much as 40% higher. And those industrial market rents have already jumped 10% in the first quarter this year, according to some of the research and reporting that's going on. So it is a really tight market in the industrial space, and we're seeing that even in little sheds where there's a mechanics, there's little industrial areas. The demand for those that we're hearing from the people contacting us is astronomical. And over to retail, obviously the cost of living demands, the interest rate hikes, things are putting pressure on the spend of households, yet the visitation numbers in shopping centres, for example, the Scentre Group, Westfield is their parent, Scentre Group is Westfield's parent company. They reported a 13.7% rise in visits across its shopping centre portfolio in the first 17 weeks of 2023. And that means that it's up 22.6% on the previous corresponding year when you do a rolling 12-month basis for that. And so one of the important things in retail is that there's a mismatch between potentially the spend and also the visits, the foot traffic, and of course, with market reviews, which we'll talk about shortly, rent increases are usually based on CPI. In March, that was around 7% CPI. So despite concerns in household spending, there's still potential for rents to go up considerable amounts. I should have mentioned before, when I'm about to change over to this next slide, coming up during the presentation, I will have pauses for questions where I'll go back to Ken and just see if there are any questions that have come through so far, and we're about to get to one of those on the next slide. So my first key takeaway for tonight is understand the market. And I know, talking to businesses every single day, that they want the best information possible to make a good business decision. And that's something that we can help them to understand. But there is also experts out there. There's research available. There are solicitors and lawyers. There are tenancy experts. There's financial advisors that you can get this information from. And not just landlords, not just tenants, but landlords can do that as well. So understanding the market is a really key point to make, and one of the key takeaways for tonight. I'm just going to pause there, Ken, and check in with you to see if we've got any questions so far. It doesn't look like it. Oh, yeah.
At this stage, we don't. But I just wanted to just remind people that you can ask just through putting in that Q&A section there. There's a Q&A on the top ribbon. So yeah, if a question does come for the next session, that please ask the question through that, and we'll try and get it answered. Thank you.
Thanks, Ken. One of the questions I get a lot is, can you tell us about the type of disputes that you see through your office? And so I've given you some data there. About 80% of our disputes relate to a retail shop lease, leaving the other fifth to be non-retail. Out of those non-retail ones, most of those come from the industrial sector. So, we've seen sausage factories, mechanics, as I said, but also in the office space, mostly those are not leased out offices with heaps and heaps of desks in them. They're an office that's for an individual professional, like it might be a chiropractor, it might be some kind of consultant, things like that. They're the ones that we typically see in our office. The larger tenants, obviously, we don't often see. The Retail Shop Leases Act doesn't actually have a limit to how small the business needs to be a tenant to come through the Retail Shop Leases Act. So we do sometimes get large firms that you would be familiar with, but they are few and far between. And this is where I like to say that I also caveat what I say with this note, that there are 473,000 small businesses in Queensland. We don't see anywhere near that number coming through our office. And so you'd have to assume for the vast majority who do lease premises, they have been able to manage those things themselves. They've been able to find out information themselves. will navigate their way through, or they haven't found us yet, which is another possibility. One of the reasons we do these types of presentations to make sure that you know that we exist, but you can also let people that you work with know, people that you come across. If you're a landlord, you can let your tenants know that we exist and that we're a mutual party. We don't work for tenants, for small businesses, and we don't work for landlords. We sit in between. Something else interesting, most of our leases that come through are written, but not all of them. This year to date, we've had 4 verbal leases where we've had disputes over those. And like I said before, we very, very rarely see the same exact lease 2 times in a row. The lease conditions vary quite a lot. And that's what my next slide is about. I just wanted to say that some of the lease terms we do see quite often, so we see them commonly, and these are the things that we see a lot, that the leases are prepared by the landlord or the landlord's agents, the landlord's lawyers or solicitors, that usually they require a security deposit, and typically that's between 3 to 6 months worth of rent. And typically they're either a cash bond or a bank guarantee. And I'll note in there that in Queensland, there is no requirement under an act for there to be a security deposit or for that security deposit to be in any particular form or for it to be registered with any government agency. And we often see if there is a bank guarantee that it comes to light that there was no expiry date on that bank guarantee either, but it is possible to have expiry dates on bank guarantees. We also see quite commonly in commercial leases make good conditions that require tenants to completely remove the fit out and repaint at the end. And another thing we see quite often is that neither the landlord nor the tenant has an entry condition report, photographs, records, any kind of evidence to show what that make good, would look like. So what did the premises look like at the beginning, so that at the end of the lease you have to bring it back to that. Quite often with the disputes that come through us, we don't see any evidence of that. Often those leases will include outgoings, and that outgoings are usually reasonably incurred expenses on top of the rent. And in fact, in the Retail Shop Leases Act, tenants must pay for things like the landlord's reasonable expenses incurred for legal fees. And quite often that will be for legal fees to both prepare the lease, but it also might be to deal with breaches of the lease as well. This is something that when we point out to tenants or tenants read it for themselves in their lease, they really weren't aware of. They didn't understand that that's actually a fee that they could be charged for under the lease. And another thing that we don't see is that the lease itself does not restrict any new lease. Once that current lease expires, there is a section about option terms in the Retail Shop Leases Act. I'm not going to go into that, but for instance, for a commercial or for a non-retail lease, quite often it's up to us to explain to a tenant that the lease that you currently have, when it ends, that lease ends. You're actually negotiating a brand new lease. Yes, for the same location and probably on very similar terms, but that lease will end at that point. That's a surprise. I'll talk about that later. Quite a number of tenants and catches them out. And the rent amount is one of the few things that we see negotiated or evidence that it was negotiated in commercial leases. None of those clauses very often have been negotiated or altered or changed, or a tenant won't say to us, oh no, I specifically fought for this or that. They say, oh no, the only thing I negotiated was the rent. I thought everything else was a given and it was just part of the standard lease. So that's key takeaway number 2. Understand your commercial lease agreement. and understand that there is no standard agreement. It's one of the things that we have to tell tenants and even landlords sometimes, that you need to read your lease and seek legal, financial, business advice to answer some of the questions that you might have about the lease. There is a link in there in blue, and you will get the slides at the end of the presentation. The Business Queensland website has a list of questions that you might want to ask before signing a lease, and also some information about who are the parties that you might come across while you're negotiating a lease. And I just want to reiterate again that the Retail Shop Leases Act prescribes minimum standards and protections for a lease that's considered to be a retail shop lease. And so there is some things, for example, sections 43 and 44 of the Retail Shop Leases Act that talks about compensation, that specifically say even if it is not written in the lease, it is taken to be included in the lease in certain circumstances. Yeah, so it's important to know that the Act can dovetail into leases sometimes. So back to the kind of disputes that we see, and what are the businesses that come to us who are in dispute. So nearly a quarter of all the businesses that come to us for a request for a dispute assistance or that apply for mediation are in the retail industry, and then accommodation and food services is just behind them. Other services, I put them there, hairdressers, professional services and repair services are third. And you can see that they make up nearly 2/3 of all of the industries that come to us. The other ones that are just below that, arts and recreational services, which includes gyms, some creative arts and tourism providers. Rental, hiring and real estate, usually those rental businesses, and then it really tapers off into very low numbers with the other industries after that. And what are the most common dispute topics? Well, nearly 35%, if you include the two together, really come down to being about getting one's security deposit returned. And that would also include those make good conditions that I was talking about earlier. Rent increases or abatements make up around 30%, maintenance and repairs about 20%. But there's also some others, outgoings, and one of the most common disputes about outgoings that we see is around the estimates of an outgoing and then the audited actual outgoings. And we've seen instances where those can vary phenomenally. 3 times the amount of the estimate was the audited actual at the end. And it probably brings me to something else that I wanted to talk about. We're not just seeing common dispute topics, but we're also seeing an environment for both tenants and landlords post-COVID. And that is that cash reserves have been depleted for both landlords and tenants. The ones that we see do struggle to deal with large sum payments. For example, if your actual outgoings bill is 3 times what the estimate was going to be, the cash flow for a small business is really going to take a hit if it's asked to pay that difference in one shot, which might well be the case written in the lease, which is a signed agreement. Don't argue with that. It's an absolutely binding agreement that you have. But the practicalities of it are that a tenant may not have that amount of money to do that type of expense all in one go. And similarly, we see landlords who, for instance, it might be a leak in a roof, it might be an air conditioner that's failed. They might not have those cash reserves to fix that all in one go, even though it might be a requirement of the lease, it might be their obligation under the Retail Shop Leases Act. The reality of it is they're not in a financial position to be able to do that. So that's one of the realities that we're seeing, and pointed out that less than 5% of our requests for assistance come from landlords. So 95% come from tenants. But I wanted to dive into each of those topics a little bit more, and I'm going to start with the most common one we have, which is security deposit returns and the make good. So I talked a little bit about this before, but a security deposit is one of those terms that I use to cover both bonds and bank guarantees, but sometimes there's other forms of security as well. Quite often it's written in the lease that they're required to provide to the landlord as guarantee of the tenant's performance under the lease agreement. And this is an area that when tenants go to actually look at their lease, they thought all along the security deposit was there in case they fell behind in rent, and then the lessor could access that money and take it out of that, and then they would have to top it up. But sometimes that security deposit is written in such a way that it's actually a penalty for breaching the lease, and you can forfeit the full amount of the bond or the bank guarantee for simply breaching the lease. Almost like a good behaviour bond in a way. If you haven't met the obligations of the lease in any way, or failed in one particular way, you may have to forfeit that whole deposit, security deposit. Most of those disagreements or disputes come about the returning of the security deposit at the end of the lease, but sometimes we do have ones where the tenant or the landlord has lost track of who actually has the cash bond, and where's that gone. Sometimes that's because of a sale of a premises. So a landlord has sold to another person. They've now taken on that landlord as landlord of the tenant. The tenant ends the lease and says, great, want my security deposit back. I've met the obligations of my lease. And the new landlord hadn't thought of it, wasn't aware of it, hadn't written that into the sale of the premises, and is now then potentially liable for that bank guarantee or the deposit. Sorry, I should say the deposit back to the lessee. And it brings me to the next point, which in Queensland, there is no government agency that holds security deposits. I can't count the number of times that I feel like tenants have fallen off their chair when we've told them that. They've rung us to say, oh, look, I'm trying to get my security deposit back. What form do I have to submit to you to get that back? New South Wales, they have a scheme for that. South Australia, similarly. In Queensland, there is no such red tape. It's a commercial arrangement between the tenant and the landlord. Sometimes an agent is involved, and they might have it in a trust account like they do in the residential world, perhaps. But there is no act that regulates those security deposits, as in where you have to keep them. It's the leases that do that in Queensland. So then the key takeaway there is that the lease may be the primary source of law, but you really know what is in your best interests. And what I'm talking about there is that I alluded to it before, where there might be those instances where there are large sums of money to be paid, outgoings or repairs, but you know your interests, you know your limits, you know what you can do, what you have access to. And sometimes you might want to try to negotiate a different outcome. It might be still to pay back that amount, but in order to stay viable as a business, you might want to do that over a period of time. And for a landlord to stay liquid, you might also need to take repairs in stages and do bits by bit. And it might not say that you can do that in the lease, but it might be something that the two of you can negotiate together. And so when we're talking to businesses about resolving or parties about resolving a security deposit dispute, we get them to look to the terms of the lease, find out what their obligations are, understand the dispute by talking to the other party. What is it that's stopping the return of the security deposit? Is it that they don't actually have that cash available, or is there some kind of disagreement going on? And what facts are clear and which are in dispute? And I talked about this before. We don't see many records of photos. An entry condition report, there isn't an entry condition report in Queensland for commercial leases that's mandated to be filled out at the beginning of the lease. But it's great practice to do that. And if you do it, I can assure you probably less likely to come across us as a dispute. Then seek help, negotiate using the facts, effective communication, focus on resolving the disagreement. And the most common goal that we see amongst tenants and landlords is that both parties want to move on. They want to resolve the dispute because it's costing them time, effort, money, and they want to move on the dispute and get back to being a landlord or get back to being a business owner and running their business. And sometimes seeking help from a third party. I talked about these before, the lawyers, the tenants advocates, the agents, they might be a good perspective for you, understanding, what the situation in, where the landlord might be coming from, where the tenant might be coming from. And there's also mediation that's available as a third party. The Queensland Small Business Commissioner's office offers a low-cost mediation for leasing disputes. And then, of course, if that doesn't work, if you've brought it to us first and it can't be resolved at mediation, it might be referred to a tribunal, or you might go on to court. And of course, you would need to bring things like your lease, your arguments, and your evidence. And this is something that we see. This is actually something a tenant told me once. Yes, I understand that I could go to court, but I don't have the evidence to prove my case, and it's a court of law, not a court of fair. So something to keep in mind. Do you want to get to that step 5, or is there another way to resolve the dispute before you get there? The second most common dispute that we see is about rent increases or abatements. And there's just a commercial reality that we've got to be cognizant of. Landlords expect rental growth. They invest their money to make money, and tenants count on the lowest possible costs in order to make money, to be a viable business. Those two priorities will compete at times. And unlike residential in some states, and not quite in Queensland yet, I don't think, there is no limit on the increases to rent. It is a commercial market. I alluded to this earlier. The market is, there is low vacancy rates in commercial tenancy, specifically in industrial at the moment. But as I said, Brisbane and Perth markets in the office space, and depending where you're looking in the retail space as well, demand is high and the stock available is low. And that makes it more conducive to friendly terms for the landlords, having a good bargaining position. And what I've said there is the catalyst for disputes is often change. So when we look at, why are people disputing rent increases or abatements or asking for abatements, it's because the landlord's changed and they've come in and there's a new landlord there and they've refigured out what the outgoings are and they've changed, or it might be that you've reached an option to renew. You've done that and it needs a market rent review and you can't agree on the market rent. There might be the end of the lease, and this is one that we see very, very often. The lease ends and the tenant comes to us and says, my lease is ended and I'm negotiating a new lease, but the landlord has just put up the rent 20%. There isn't anything in their lease that they can find that stops them from doing that, because they're actually in the middle of a commercial negotiation. They're trying to negotiate a new lease. And the other change or catalyst for rent abatements is refurbishments or major works in shopping centres and the impacts that they have on tenants. just about to come up to a questions stop, but I just wanted to get through this key takeaway 4. So there's a saying, I can't remember who said it, but it is that the most dangerous negotiation you can be in is the one that you don't realise you're in. And so understanding that you are negotiating and understanding your negotiation strengths is a really key takeaway for both landlords and tenants. One of the things that we see with options to renew or the ends of the lease term is you need to allow enough time for that negotiation to happen. If you can imagine, if you have a rented property and your lease ends on the 1st of June and you're having the conversation about trying to sign a new lease now, you've got very little time to exercise or to execute a new lease. And if you can't agree on those terms, you have very little time to move somewhere else, find somewhere else, research where you could move to, make sure that it's got the right DA approvals, all those kind of things. So you're at a disadvantage because you haven't given yourself enough time to negotiate. And time to negotiate is a really important strength that you can use when you are negotiating a new lease or some change in your lease or trying to get through a dispute. The other thing that we ask usually tenants to calculate is your costs. And there are people available if you're in financial distress. There's small business financial counselling service in both the north and south of Queensland that are funded by the Queensland government, whose role it is to help a business understand their finances better. And so they can help you calculate what the costs might be of moving, of making good. What would be the costs of staying? So if you do pay that extra 20% on the 1st of June, is that going to be equivalent to the costs it would be of you moving, relocating all your equipment, perhaps the loss of staff, key critical staff, and trying to replace them because you've had to move elsewhere, things like that. So calculating your costs is important. And like I said before, good decisions are made with as much information as possible. And so information about what other tenants are paying, what are the landlord's plans for the premises. There's no point you trying to negotiate to stay past the 1st of June if the landlord has plans to redevelop the whole site and there's no way you can change it so you can stay in there. If you don't know that information, you're at a distinct disadvantage in that negotiation, and it's going to end badly for you. What's the market situation? Know your market is what we said before. And is there even availability elsewhere? The other thing to consider is how often do you negotiate? Are you a good negotiator, or do you need an expert or some training, to upskill yourself in this? There are resources there that can help you, but as I said before, there's also people that you can pay as specialists to help negotiate, both as a tenant and as a landlord.
All right. So, yeah, Pete, we actually do have a few questions that have come in. I just asked the first one.
Yeah.
Why is there no standard lease conditions or standard way of administering business leases? Just a question, seeing the variability we have seen so far as a tenant.
Yeah, really good question. One that I'm sure will come up when the Retail Shop Leases Act is reviewed later this year. I am in a position not to be able to speculate, why things are like that now, but I can explain what other people have told me. Others have pointed out that any kind of regulation, there's another name for that, which doesn't have a really good connotation and is really hard to sell. That's called red tape. And it's really hard to sometimes differentiate or understand what the difference between is good tape that might assist, and red tape that will get in the way. And who does it assist and who does it get in the way of? That's probably a really good question about, why, or that might answer why there is no standard lease. in Queensland, or no standard terms for leases in Queensland. Perhaps it has to do with not wanting to over-regulate a sector. If you don't agree, if you think there should be more regulation, as I say, Retail Shop Leases Review, it's open for consultation, I believe, later in the year, and there's your opportunity to try to change that.
Awesome. Thanks, Peter. I've actually another question here too. What obligation does a landlord hold to provide repairs to a building or to provide ongoing maintenance to a building?
That's my next section. So what a great segue. If that person doesn't mind, you don't have a voice, I'm afraid, because everyone's muted. So I'm just going to go on to the next section so I can answer that. Is that all right, Ken?
Yeah, that's fine, Peter. Yep, thank you. Yep.
Awesome. Let's do that. I think the question was, correct me if I'm wrong, Ken, what are the obligations for a landlord to repair or fix, things? Is that right?
Yeah, and to provide ongoing maintenance.
Ongoing maintenance, yeah, rightio. So we'll cover this a little bit later, but it's probably tied up with those key takeaways that I've been saying. There's no standard lease. It really depends on the lease. And also the Retail Shop Leases Act. There are some sections that deal with compensation. I believe it's section 43 and 44. I know it's in Division 7 of the Retail Shop Leases Act. So, if you want to look further into that and you're a landlord of retail leases in Queensland, that would be where I would point you to, and you could get some advice on that and how it applies in your situation. But I'm going to ask a question, which is, everyone is in it together. Landlords and tenants are in it together to make the best of the premises. That's the key goal. You want to make the best of the business that occupies it, don't you? Well, let's be real. Everybody has their own business interests. People have different ways of running their business and putting their interests above others. They have different needs in terms of cash flow. The landlords that we see, the vast majority are not large commercial landlords. They are individual investors or people with one or two properties. I remember distinctly this story from when we were dealing with the COVID rent abatement period. There was a landlord, there was a hotel owner, like a pub owner, and he had the pub, and he also had, he had the lease for the pub, and he also had a lease for the bottle shop. The landlord for the pub was a large multinational company, and they came to the landlord. It's hard because he is a landlord of the pub, but he came to the business owner who ran the pub and said to the business owner, we're going to abate all of your rent for the foreseeable future. I think it's about 6 months they gave him rent-free in your pub. Don't worry about it. We'll look after you. We want you to stay. And then didn't hear anything from the landlord for the bottle shop. Lodged a dispute with us and asked us to try to do a mediation. At the mediation, and this is what the business owner told me afterwards, he had a picture that it was similarly another large company who owned that bottle shop premises and couldn't understand why they wouldn't, abate that rent. It turned out that the owner was an individual. He was a father of a person with a disability. That person had been in a motorcycle accident, and the compensation that they received for the accident, he had invested in this bottle shop in order to keep an ongoing income. So because he was full-time carer for the son, he needed something that could give them passive income and he would still be able to look after his son. And it wasn't until the business owner had discovered that at mediation that he understood that there was two different realities going on here. There were different circumstances, and it was a misunderstanding. It was assumptions on his part of the position of the landlord. And I've got to say that most of the landlords that we see are not the large commercial multinational companies. We very rarely see them come through our office. So yes, there are responsibilities, there are obligations, communication. Everybody is not great at it. Let's face it. Some people communicate better than others, and some people are more effective communicators than others, and that causes differences, misunderstandings. It causes friction, and it creates problems, and that's why there are disputes. So that was a long way to get to the what I hope is the answer. There are two competing priorities: a landlord expecting a return on investment and tenants counting on the lowest possible costs to run a viable business. A commercial lease will almost always set out who should repair and maintain certain items of the property. And if you do any Google search on commercial maintenance and repair disputes, you will find dozens of articles written by lawyers. There's also articles written by commercial tenant advocates. I know there's articles or blogs on LinkedIn about this topic, specifically about things like air conditioning units that you can look up and find out information. But essentially they say, what does your lease say? Or are you a retail shop lease? And should you be looking at this Division 7 of the Retail Shop Leases Act to point you to what your obligations are? It's important to point out also, we have seen many a commercial lease, a non-retail lease, where an express clause which requires the landlord to undertake structural repairs is not included within the lease. And you may need to seek advice where that leaves you as a tenant. You also might need to seek advice about what's maintenance versus repair. And I'm going to tell a short story about an air conditioning unit that we had a dispute over. When we asked the tenant to look what it said in the lease, they discovered, much to their surprise, that the lease said that they were to pay for a professional service of that air conditioner for every 6 months. And if they did not do that and the air conditioner broke down, it was their responsibility to repair the air conditioner. If they did do that and they had the records of that, it was the landlord's responsibility to repair the air conditioner. And so it came down to what was in the lease. Hopefully that answers that question. But basically, if the parties can't agree on repairs, maintenance, bond returns, those other disputes that we see, then the Retail Shop Leases Act and the Small Business Commissioner Act says that they can be decided by the way of the dispute resolution process that sits there. And so what is that dispute resolution process? That's what I'm going to talk about now. So we often see that it boils down to 4 things that parties can do in a dispute resolution process. They can do nothing and wait to see if things get better. They can try to negotiate with the other party or seek assistance to try to negotiate it. They can use a mediator to try to settle it and keep it out of court, or they can seek a legal judgment. And I'm going to talk a little bit more about what mediation is, what our office does, and why we do that and how we do it and things like that. It's important to note in the retail shop lease disputes, you have to apply to the Queensland Small Business Commissioner for mediation before you can go to QCAT. It's a step before QCAT, unless it is an urgent intervention that you're seeking, and sometimes mediation is not suitable for when those urgent interventions are needed. If it's a non-retail shop lease dispute, then both parties can choose to try the Queensland Small Business Commissioner's office for a mediation before going to court. And it's important to note that more and more courts are actually ordering parties to go to mediation before they'll hear them anyway. It's a fact of life that business dealings and relationships, they'll lead to disputes, and business relationships and contracts regularly strike trouble when something unexpected happens, or when one side doesn't think the other side has delivered what was promised. And so mediation is usually the best way to resolve the dispute. And I'm going to talk about why. But before I do, just going to go to the fifth takeaway, which is these are basically those 4 things that were in the previous slide summarized. You can hide it out, you can fight it out, or you can communicate it out. And I'm going to talk about communicating it out through mediation and what that is. It's a structured negotiation. It's where a mediator follows a 12-step process, usually, to allow parties to retain control of the decisions made in mediation. It's a process that takes time, around about 4 hours on average for a mediation to occur. In our office, it's about 52 days from the point where we get a request for dispute assistance to the point where there's either an agreement or we have to refer it to somewhere else or close it as no resolution. At the moment, we're tracking at around 70% of mediations result in a signed agreement. When we try informal resolution first, so even before mediation and our office gets involved, we see about an 80% completion rate for those disputes. So they're resolved 80% of the time, even before having to go to mediation. So yeah, I hope that describes what mediation is, but mediation and negotiation, they're hand in hand. I'm just going to use a quote from Albert Einstein. You might have seen this one before. It's up there, you can read it, but there's some preparation that we can help parties with, and understanding the issue is one of the key things. There's a checklist that the Australian Ombudsman has prepared that we've got a link to help you do a 7-step process to try to understand what the dispute is and what are the options for you to resolve that dispute without having to go to court. It's really great for using before you negotiate, also really great before you go and do a mediation with a mediator. And it's also really important to think about what the outcome is. What's the most important thing to you? We talked before about one of the key takeaways is that you're the person who controls what's in your best interests. But thinking about what is your best interest, what is the thing that you want the most? Do you want to be paid? Do you want more work in the future? Do you want the relationship to continue? Is that more important than this particular instance or dispute? Or do you want to move on, move out, finish up? These are some of those things that you need to sort of uncover as part of the process and then get some help to check. So there's 5 reasons why you'd mediate. They're on the screen there. I'm not going to go through each of them, but there's speed. It's 46 weeks for a retail shop lease dispute at QCAT, and that's advertised on there. That's reported on their website. That's not me making up that figure. So 52 days for us on average to resolve a dispute, 46 weeks at QCAT, and the others are there. I know I'm almost out of time, so I'm just going to run through these last ones so we can get to any questions. I've probably said this several times, but there is people there that can help you. There are professional negotiators if you're not great at negotiating. There's agents that can do things on your behalf. So use the expertise to gather the information, do the research, have the conversations, find out what the other party is actually wanting. You can seek advice and get help, and that's actually the last of my takeaways. So I'm going to just run through them again. It's important to understand the market, understand your commercial lease agreement, because there's no standard one. And although the lease may be the primary source of law, you know what's in your best interests, and understanding that and that you're in a negotiation and what your strengths and weaknesses are in your negotiation is really important. You've really got 3 choices. You can hide it out, hope it goes away. You can fight it out. That might cost you a mozza, but you might win. Or you can communicate it out, which is usually the best place to start. in our experience. And seek advice and get help. There's plenty of advice out there. And one of the ways that you can seek that advice is to contact our office, and our details are there. And that actually brings me to the end of the presentation. So I just wanted to throw back over to you, Ken, and see if there were any last questions there for me.
I don't have any questions at this stage, but I might just give it a quick tick, just to see whether there's any that comes through. No, doesn't look like we do have any. So well, yeah.
I just wanted to end by saying what I said at the beginning, which was thank you for giving up an hour of your evening to listen to me. I hope that you're able to get something out of that, and that if you're a landlord or you're a tenant and you're in a dispute, you can think of us, or you hear about that with a colleague or a friend. You can think about the Queensland Small Business Commissioner's office as an option, as that mutual person in the middle, just trying to bring the parties together and resolve disputes, because we know that both of you want to move on and get back to business.